Welcome everyone. This is the VanIAC panel. We have some good geographic diversity here. John Siwiec from Ottawa and Gerry from Vancouver, Palm Springs, and Julie Hopkins from Calgary. I will just do brief introductions of each of them and then let you know how we're going to proceed. So Julie is at the Western Arbitration Chambers. She's an independent arbitrator based in Calgary, more than 30 years of experience in dispute resolution. She's formerly of Borden Ladner Gervais in Calgary. She's a fellow of the Chartered Institute, and her website says she's the chair of the Canadian chapter. I think that might need to be updated because I think you're no longer the chair. And she has taught at the University of Calgary as well. John Siwiec down at the end is a partner at Purdy Robertson in Ottawa. He's a member of Arbitration Place's Next Generation roster. Counsel and arbitrator in domestic and international arbitration, formerly a YCAP president, and he has also taught at the University of Ottawa. Gerry Ghikas, KC, in the middle, is an independent arbitrator. As I said, he's based in Vancouver, but those of us that know him well know that he spent some time down south of the border where it's warmer and doesn't rain as much. He's got more than 40 years of experience. That might need to be updated as well. In domestic and international arbitration. He's also formerly a VLG, so there's a bit of a VLG theme here. I don't know how exactly that happened. I was a late addition, so it's not my fault. And he's one of the founders of Ghikas, the Western Canadian Commercial Arbitration Society, and there are other members here. Our topic today is, it's quoted as, ask us anything from appointment to PO1. And we are going to talk about from nomination appointment of arbitrators to procedural order number 1. And in theory, you'll be able to ask us anything, but that doesn't necessarily mean you'll get an answer. What we propose to do is to deal with the issues that were actually set out in the program in the order that they were. We have different perspectives up here. All of us can actually talk about different perspectives, but for the purposes of this, Julie is going to give us more of a sole arbitrator perspective. That was a main role of hers. Gerry is going to give us a tribunal perspective when you have a 3-member tribunal, having sat on more of those than any of the rest of us. And because both of them have forgotten what it's like to be counsel, John is going to give us counsel's view of how some of these things play out. In looking up, not that I needed to because I know them all very well, but I thought I'd look up their websites. And Gerry's website has an excellent little segue to get us started. Is under the heading in one of his pages, it says case management approach. And he puts it right there for everybody to see. So you know what you're going to get. And the beginning of it says, much of the work required to ensure a fair and efficient process occurs at the beginning of the arbitral proceeding. And I think that was a great segue for us to start on these issues that we see arise early on in a proceeding, and beginning with the arbitral nomination and appointment process. In the materials, it said pros and cons of specialized experience, and we'll touch on that and some other issues. And Julie's going to start us off on that topic. After each of the, even though there were 5 bullets, we've kind of put them into 3 separate sections. We will open up the floor for the questions. We're not going to wait till the end. We want to get some interaction, challenge what's being said, and offer different alternatives, because some of these issues, there are many different perspectives, and we can't all be right. So, Julie, off you go.
Well, I feel like I should start this like some panelists from major corporations and say that the opinions that I might express are my personal views and not necessarily the views of Julie Hopkins, arbitrator. So, the topic is a subset of a more general topic about what you should be considering when appointing an arbitrator, and the ability to appoint your Arbitrator is considered to be one of the great benefits of arbitration. In my view, the great benefit is actually the ability to not appoint people, but that's a discussion for another day. So because you have the ability to pick your own decision maker, should you appoint somebody with subject matter expertise? And if you look at the VanIAC roster, you're going to see a very diverse group of people with all sorts of different backgrounds. So if you have a dispute involving a construction issue or an oil and gas issue, do you want somebody who is an industry insider? Do you want a lawyer who has worked for the players in that industry? Or is it better off to simply have a blank slate? Well, it's often thought that there are some real benefits of having someone with subject matter expertise. For one, you don't have to educate them the way you would have to if you have a blank slate. It's also thought that the expert arbitrator can help streamline the process because of their expertise and their ability to narrow the technical issues. There's also the view that they're better positioned to come to grips with the expert evidence and will lead to a better quality of decision making. And it's sometimes expressed that if you have an expert decision maker, because of their industry experience, they may have more credibility and therefore their decision may have more legitimacy with parties. And I think these are all true and important considerations, but there are a few risks when appointing arbitrators with subject matter experience. And these risks can be manageable and might even be acceptable, but there's still something to keep in mind. So the first one is something that was raised earlier, and it's the potential for conflicts, and in particular, the possibility of mid-process conflicts arising because the arbitrator is experienced in the industry. They often have a lot of relationships, and it may later become apparent that somebody's witnesses or a late appointed expert may raise a conflict. In my view, this is an issue that is quite manageable if all the parties are alert to it up front and are operating in good faith. The early exchange of witness lists, including expert names, can largely alleviate a lot of these issues. Of course, you never know how things may ultimately turn out, but you know, it certainly is not anything that's insurmountable. And another point, and this is of particular relevance when you are appointing a sole arbitrator, is whether the individual you are considering with this subject matter expertise has experience in running a hearing. Part of what you're buying when you buy an arbitrator is not just the substantive decision making, but the ability to run a hearing in a cost-efficient, fair way, and most importantly, a hearing that results in an enforceable award. In the absence of experience or at least training as sitting in as an arbitrator, you are taking the risk that the arbitrator's process could undermine an award no matter how correct the actual substance of that award may be. And this takes me to my third point, and to me this is actually the most fundamental concern and more difficult to navigate, and it's issues that arise in the context of natural justice. When you appoint someone with subject matter expertise, they will approach the problem with their own views, experience, assumptions, and biases when they're evaluating the facts. And why would that be a problem? Well, the Chartered Institute's guideline on party-appointed and tribunal-appointed experts puts it this way. Arbitrators are often chosen in part because of their expertise. However, care should be taken by arbitrators when basing their arbitral award on their own individual analysis, because in some jurisdictions this could result in a challenge on the ground that the arbitrator has overreached their powers if such analysis has not been raised and or discussed previously with the parties. So this really comes down to the parties knowing the case that they have to meet. Under Article 24.3 of the Model Law, it states, Any expert report on which the arbitral tribunal may rely in making its decision shall be communicated to the parties. So if an arbitrator is going to make a decision based on their own expert analysis of the facts, it's imperative that they disclose that analysis to the parties so the parties have an opportunity to be heard on it. But of course, this raises another risk, and that's the risk of an apprehension of bias. Because if the arbitrator's analysis is in favor of one party or another, or is material to the outcome of one issue or another, and it should be if you're going to be raising it with the parties, you have to then manage how that's going to appear to the people that you're working for. There's an interesting article I came across by Paul Klaus. It's entitled "The Value of Peach Orchards, the Perils of Arbitrator Subject Matter Expertise." Some of you may be familiar with it, but I would recommend it just because it's interesting, and it's also quite an entertaining read. And in it, he talks about a number of cases where arbitrators with subject matter expertise went off topic and out on their own, and then imperiled the award. So those are my thoughts on the matter.
Thanks, Julie. Gerry, any observations from a three-member tribunal perspective on this issue?
Well, sure. I think you've probably heard these thoughts before. When you have a tribunal, you do have an opportunity to get a blend or a range of experience, and that can definitely enhance the end product, the award. Personally, I think that subject matter expertise of arbitrators generally is overrated, probably more by the parties than by their counsel. I think counsel are generally familiar with the fact that if you have an experienced arbitrator, you're going to, through the course of your submissions and the expert evidence, you're going to be able to educate them to the extent necessary. Having said that, there's no doubt that when you're on a tribunal, to have someone who's conversant with the vocabulary, has a general appreciation of the industry, it can be very valuable to you in understanding evidence and in formulating questions that you want to put to counsel. It's when you're over the break, you may sit and say to your colleague, "What the hell was he talking about?" when he was talking about the lower widget, and that's explained to you, and then you can ask the question to get the explanation on the record. So it has its advantages. I think the sweet spot, to conclude, is I think the sweet spot is if you can find someone who has previous experience sitting as an arbitrator in cases in the particular industry. That's usually, in my view, the best combination, because they will have picked up to the extent that they need to the industry-specific knowledge, but without having too much expertise in the area to stray into the difficulties that Julie identified.
And Gerry's numerous industry expertise is, I think, on his website. John, from counsel perspective?
I think from counsel perspective, to add to what's already been said, the preference would be to engage your own expert as as a party appointed expert, rather than and then have that expert on the tribunal. Not only is there a little more control that you can have with your expert, and you don't need to say anything nefarious about that control. Of course, the expert's going to remain objective, but to be able to have that ability to find your own expert rather than finding that expert as the decision maker, because as you said, there's so many potential potholes that can come along the way when it comes to award enforcement and any issues of being able for the parties being able to make out their case and to have the case heard. If the expert is not familiar with just the regular procedures and process that they should be looking out for throughout the course of the arbitration, then you can avoid some pitfalls down the road. So I think from counsel's perspective, having the ability to appoint your own expert would be the preference. And I think it depends on the nature and the size of the dispute itself, but the preference would be for that.
Can I have one more related thought?
Absolutely.
Within the Canadian arbitration community, my sense is that there's not broad acceptance of tribunal-appointed experts. And all the reasons why counsel cringe at the notion of a tribunal-appointed expert should make them pause when they think about having an arbitrator with too much expertise, because the same sorts of concerns should arise. I happen to think that tribunal-appointed experts are underutilized, but that's just my personal view.
And there's a whole other debate on the utility of expert evidence and the scope of it that people see and the complaints that arbitrators have about over-experts, but that's not for us. And yes, excellent timing, Joel, because I was just about to turn it open to the floor, given that we seem to be all on one side of this page, although mildly stated, it would be good to hear from both.
Yeah, based on my experience as counsel and as arbitrator, I think a useful distinction should be drawn between arbitrators with subject matter experience as opposed to subject matter expertise. I've been involved in 2 or 3 situations where they were expert arbitrators appointed, and it turns out they had a very, very too close relationship with the experts who were retained by counsel for testimonial purposes, to the point where at one point the witness called the tribunal member by his first name. And that actually proved to be very problematic in that case. So I think there is a difference that people should consider between experts, in quotes, as opposed to people who happen to have some experience in dealing with a particular type of case.
Thanks. Anyone else? Yeah. Martin?
I would just make the obvious point that if you do want a decision by an expert, you can go to expert determination. And that way it's clear that it's not an arbitration, and in fact, if you consider what expert determination is, you're actually buying into a process where the expert can do all sorts of things that arbitrators can't do. They can consult their own materials. They can rely on their own expertise to make a decision. It can be very quick. So I would just say, instead of if you do want expert determination, go with that process rather than arbitration.
Martin, anyone else? Yeah. Another hand at the back. I can't see who it is. Oh, there.
Sorry, it's Peter Ashford from England. We had a case in England very recently about a sole arbitrator who was an industry expert, not a lawyer. And when the experts appeared before him, he said, well, I know all these people. I'm going to accept what they say. I don't need to have them cross-examined. He was removed for bias.
That's excellent. Anyone else on this topic before we move on to the next one? Yes, please.
Just a comment on tribunal-appointed experts, which are, of course, much more used in the civil law system because the courts often have their own experts. I suggested it on a couple of occasions in an effort to kind of streamline things in cases which weren't that large and which were going to cost a lot for experts. And the only times I've ever suggested, it's the counsel who said, no. Because if it's a tribunal-appointed expert, how do I know that he gets my side of the story right? So it's a really difficult position, I think, in common lawyer. Just to insist that they have control over the brief and what experts are actually going to testify.
Anyone else on that topic? Okay, I get a final word then. We actually had a circumstance where after the experts had testified at the hearing, the tribunal asked whether the parties would be willing to convert them to tribunal experts for the purposes of their deliberations. And what they would do is alert the parties if they wanted to talk to the experts, at which point the party would no longer be allowed to talk to their experts. And counsel agreed. They never used them, but we did agree. And it's kind of a hybrid way where you had your experts, they done their testimony, they've been cross-examined, and then the tribunal may, need to plug numbers into a model, or might say, well, you said this and you said that, and we just want to get clarification. It does make counsel nervous because you don't know exactly what would be going on behind those doors, but it is another option. So we're going to move on to the next two bullets because they're related. Rates. So let's talk about the money. Can they be negotiated, which is always an interesting scenario when you're counsel. And what to do when three-member tribunals have different rates, and then how all that plays into the terms of appointment and what you should or should not include in that document. And for this one, Gerry's going to lead the discussion.
Okay, well, let's start by talking about rates, particularly in the context of a tribunal. I think most arbitrators in Canada that I'm aware of, and let me back up one step. Many of these issues you have to approach with a different perspective if you're dealing with an institutionally administered arbitration versus an ad hoc arbitration. When you think of the ICC, Siwiec, ICDR, the fee arrangements are all, and the communications with the clients about those all take place through the institution. And it's not only the economic relations, it's also other aspects that you might normally address in a terms of appointment document. So in my experience, I don't ask the parties to sign terms of appointment in an ICC case, a Siwiec case, or an ICDR case, for example, because the things that are concerned to me are generally addressed by their internal rules or by their remuneration practices. Having said that, within Canada, our domestic administering institutions have a lighter touch, less intensive involvement in the process generally. I'm thinking of VanIAC, for example, or ADRIC. And in those instances where I get an appointment, I do ask the parties to sign terms of appointment, whether I'm sole arbitrator or whether I'm a member of a tribunal. So my comments about the terms of appointment are in that context, where you've got an ad hoc arbitration or where you're one of these more light-handed domestic institutions. As far as rates are concerned, in my experience, most arbitrators have what they think of as a standard rate, just the same as counsel do. Although personally, I have a range of rates that I quote when people call me, and it depends on where the arbitration is seated, whether I'm the chair or the winger, the amount involved, complexity. So I try to keep my powder dry. I will tell people what the range is, but I try to leave myself some flexibility until I know a bit more about the case before I zero in on the rate. But I have to do that when it comes time to sign the terms of appointment. In the tribunal context, most of you are probably familiar with the practice that's developed in Canada in ad hoc cases where it's thought to be desirable that all three arbitrators be paid the same rate. Getting there can be interesting because you can sometimes have party appointees with widely ranging levels of experience and rates, and similarly the chair or presiding arbitrator may be even more experienced than the others. Where you're within a relatively narrow band, the general practice is simply to average the rates and agree on a rate amongst the arbitrators to quote to the parties. But you can't always get there because sometimes the differences are too great. There have been a rare number of instances where I've seen the chair paid at a higher rate based on experience, not because the chairs work harder, because you're generally paid by the hour. So the more work you do is reflected by the number of hours you put in. You don't need to have a higher rate as well. But often on an experiential basis or just the law of supply and demand, there's justification for the chair to get a slightly higher rate. So when you're contacted as an ad hoc arbitration to be a party appointee, I think the wisest course is to say, well, generally my rate is if you're asked, is in the range of X to Y, tribunal, there's probably going to be some discussions amongst the tribunal members in due course about what the financial arrangements would be with both parties. And so, you know, the final rate is going to be the subject of those discussions. And not lock yourself in had unfortunate situations where I've been serving as the chair of one of the party appointees has basically promised the party that appointed them a very low rate, and they've been stuck with that, and that's made things a little bit awkward in the administration of the tribunal. So let me, having dealt with rates and how you get there, let's just talk a little bit about the other aspects of the terms of appointment. What I think best practice is, in the cases that I've indicated, to have a contract between the sole arbitrator and the parties, or the three arbitrators and the parties, all in one agreement, setting out the basis on which they're going to be paid and how the billing is going to take place. But you can also use this document to cover off a number of other issues that you would like to get out of the way at an early stage in the case. So I will typically in the recitals recite the fact that there is an arbitration and who the parties are, and that it was commenced on a particular date. Dealing with an ad hoc arbitration, sometimes there's uncertainty as to when the arbitration was deemed to be commenced. This is an opportunity to nail down the date of commencement of the arbitration. Confirm the validity of the appointments, that disclosures have been made, parties are satisfied with the disclosures, and confirm that the tribunal is duly constituted. And I don't go so far as to try and deal with jurisdictional issues, but I've seen that dealt with as well. I think it's a good idea in the terms of appointment to spend a little time talking about the basis on which disclosures have been made. We had a very interesting panel a few moments ago talking about the gray areas that can surround disclosure, who's doing what. In the standard terms of appointment that I like to use, I say to the parties, do you understand that I have based my disclosures on the names of the parties that you gave to me, and I have not done other searches. Now, in some institutional appointments, I can't say that because the institutions expect me to do other searches. But in an ad hoc case, I like to put the onus on the parties. So you give me the names, I'll do my conflict disclosure on that basis. I refer to the fact that I have a CV, and the parties confirm they read my CV, and I have a lot of stuff in my CV about the organizations I belong to and the cases that I've worked on, and my approach to case management and so on. And I think that's a useful thing to do. And then the third component of it is to get the parties to represent to me that they are not aware of any circumstances that might be disqualifying for any of the arbitrators. So those are wholly apart from the financial terms. Those are useful provisions to include in your terms of appointment. As far as the financial terms go, they can be expressed in a number of ways. In my earlier remarks, I was assuming an hourly rate, and that is the most common, but there are also a number of arbitrators who like to quote it and get agreement on a daily rate. So for hearing days, and in some instances, they'll say my daily rate applies anytime I have to spend more than 4 hours in a procedural conference or whatever I'm going to get paid for a day's work. That approach can be taken too. You may want to quote separate rates for travel, depending on the nature of the case. In some cases, I think probably influenced by the ICDR's approach, I've also seen it broken down rates for what they call study time, preparation, hearing time, and travel time. I tend to just have to say rate throughout, but all those things are open for discussion and negotiation with the parties. What I do, and I think it's the best practice, is send out, once we have some rates and consensus on rates amongst the tribunal members, send that out in draft to the parties before the first procedural conference. Because if you're not able to come to terms, something's going to have to give. You may have to, I've never had it happen, but theoretically, I guess, if somebody said, I'm not going to pay these rates, you would say, well, then I'm not a practice arbitrator. And you have to get that issue out of the way first. So you send it off to the parties, give them the opportunity to comment, and in a meaningful way. Typically, you won't get much feedback on the rates, but you may get feedback on things like cancellation fees, which is a topic ripe for discussion. I won't move too far into it now. We'll see, let others comment on it. Maybe there'll be people in the audience who want to talk about, or ask questions about cancellation fees. So there are other things you deal with in the terms of appointment. What's going to happen to the documents that you've been given at the end of the case, on right to dispose of them within a certain period of time or return them to the parties. Probably a good idea to include an arbitration clause, or at least some sort of dispute resolution clause, if you would rather not get sued by the parties. They dare to do that in a court. Good idea. Which reminds me that another important aspect of the terms of employment is to build in some protections against liability. Very common to see a community from being called as a witness. Some words limiting liability to very extreme cases of fraud or something like that. Shorthand way of doing it is often to just say the same immunities as with a judge of the Superior Court of whatever province if you're in a domestic arbitration in Canada, and clothe yourself with that protection as well. So I'll stop there and let others talk.
Is there anything that, in your experience, the terms of employment should not do?
I don't know what you're fishing for, Greg. I said earlier, I don't go so far as to try to nail down a jurisdiction. I really think you're talking about the business terms between the tribunal and the parties. Don't mix those up with issues of procedure, jurisdiction, any of those things. That's for a separate process.
I did sideswipe him on that one.
Yeah.
What I was thinking of is I've seen terms of appointment and the tribunal sends it out and they title it arbitration agreement.
Yeah.
And that's very dangerous because the parties already have an arbitration agreement, usually, unless it's they have a submission agreement or it's in their contract. And if you call those terms the arbitration agreement, you create some confusion. Is that superseding their agreement? Is it supplementing it? What is it? And so I think it's extremely important that it is the business terms in the relationship between the tribunal and the parties, and you're not endeavoring to get into the relationship issues between the parties.
Can I just add one? I left out one very important topic, and that is deposits. You want to, in those terms of appointment, make the superior right to require the parties to make deposits in equal amounts. I generally prefer that the parties be jointly and severally liable for the lawyers, for the arbitrator's fees. Some parties balk at that, and I say, well, your protection is the deposits. You may not like being jointly and severally liable with your adversary, but if I've got enough money in the pot so my fees are paid, what's the worry? That there is many institutional rules follow a similar path. So having the right to get deposits and confirmation as to where they can be held, and the right to top-ups at appropriate times are all important things to deal with.
John, from a counsel perspective, how often do you see the parties looking at the terms of appointment and getting on the phone with each other and saying, oh crap, what do we do with this? They want how much? And they want cancellation fees 6 months in advance. I mean, how much pushback do you actually see from counsel on terms?
Well, I think that's a good question because you want to always take a light touch, especially at the outset. When you're trying to establish a relationship with the arbitrator, and you want to avoid any kind of negative reflex from the arbitrator if you're pushing back on rates or cancellation fees that presumably you would have known before appointing the arbitrator. So it's one of the initial inquiries from counsel is always, well, what's the availability of the arbitrator and what's the arbitrator's rates? And preferably you're doing that through an institution, an appointing authority, or some third party that can ask those questions, those uncomfortable questions that counsel can try to avoid, so that you don't kind of start off on the wrong foot, but a bad foot, kind of questioning, your potential arbitrator or your appointed arbitrator about their rates. So it's always a delicate touch, and one that you try to avoid, I think, as much as possible.
And Julie, feel free to jump in on this one, but I think Gerry might have a view as well. And this is a really practical thing, and sometimes you put it in terms of appointment. I think it's probably a good idea. It's probably going to invoice when you have a 3-member tribunal, and what should be on those invoices, and it relates to the rates and how it's done. So
Yeah, I can speak to that in this one. There are actually two different practices that I've seen at play in Canada amongst Canadian arbitrators. Uniformly, I advise that the terms of appointment should make it clear that when you get an invoice in whatever form, it is only going to tell you the number of hours spent multiplied times the hourly rates. It's not going to be broken down like a lawyer's with discrete descriptions of the services rendered, because you don't want to tell the parties about your deliberations, specifically what you've been doing. So, and parties are generally accepting of that. I've not had pushback at all. Where the practices diverge, my preferred practice is I just get, if I'm the chair, I ask my colleagues to provide me with their separate invoices. So, X hours times X dollars per hour, and whatever the taxes are, they're applicable in their jurisdiction. And then I send those along with my own to the parties. I will have enough money on deposit to pay them, and I pay them. And then inform the parties that that's occurred, and this is how much remains in the deposit. So that, in that instance, the parties know what each of the co-arbitrators, how much time each of them has spent, and how much time the chair has spent. Some arbitrators prefer a practice where that's done, where a single invoice is issued for the services of the tribunal, total number of hours times the rate that everybody's charging, the same rate, as is normally the case. The rationale that has been explained to me for that is that you don't want to signal to the parties who's doing what. Because the reality is, when you're on a tribunal with 3 arbitrators, it's not automatic that the chair does everything. Very often, discrete tasks at different times, depending on people's availability, are taken on by the co-arbitrators. And so there's a concern that if someone says, "Oh, look, your co-arbitrator put in way more hours than my co-arbitrator. What's that all about?" And so to diffuse any of those kinds of concerns, some arbitrators like to just have a consolidated bill. So be interesting to hear what the thoughts of counsel are, and as to what their preferences are, more importantly, their clients' preferences are in terms of consolidated billings or individual billings from tribunal members.
Give Julie a word, and then we'll open it up to the floor.
I just wanted to highlight one thing that Gerry was saying in the importance in an ad hoc arbitration of making sure that all of your commercial dealings are running on a separate stream than any of your financial things. And it can kind of get mixed up. For example, when you're talking about deposits, you might have different communications on more substantive issues. It's very easy just to drop in the, "Oh, by the way, we're going to do a top up and here's," don't do that. Just take that, send a separate email on that, make sure you're vigilant on keeping them discreet at all times. You don't want to ever have a situation where, heaven forbid, it goes to court and all of your financial ins and outs are out there. We don't need that. So just be vigilant, keeping them separate.
So, any questions on rates and terms of appointment, yes, I see a hand up over there. Hand up.
Jackson, let me speak first. Yay!
Mary Como, Vancouver. I won't say from Vancouver, Craig. I'm wondering if any of you have any experience with escalation clauses. I've started to get those from other arbitrators. So the idea is, here's our rates. If this matter goes on for more than 2 or 3 years, just time frame, we reserve the right to renegotiate fees with the parties. I've seen those. I've not ever had to go ahead yet and try that renegotiation. I'm just wondering if anybody's had that experience in terms of putting them in and or having to deal with them.
I haven't seen that area. The first thought that came into my mind is it's an unhappy signal to send to the parties right at the beginning of the case might go on.
I've seen it in cases where parties have presented you with their timetable,
Oh,
but
yeah.
it's years out.
Oh, we'll come to that next.
Gerry, in my agreement, and I don't call it an arbitration agreement, I call it an arbitral appointment. I have a clause in mine that says usually 1 year after I can renegotiate the rates with the parties. I've never exercised it ever, but it's in my agreement. I wanted to ask you a question. At least one arbitrator in Toronto who has had a clause, if the agreement signed 11 months, say, before the scheduled hearing, the clause will say, if you settle after 1 month, I get 1/11th of the amount. After 2 months, I get 2/11ths, etc., working itself down. I've never done that, but I know there at least one arbitrator, if not 2, have done that in Toronto. Have you seen that before?
I haven't seen anything that dramatic. Cancellation fees provisions are pretty normal in my experience now. When I first started practicing, people were afraid to even suggest them. But a few of us were quite insistent about it, and I see it now quite widely used in domestic arbitration in Canada. Typically, they kick in 90 days out of the hearing, so that there's no cancellation penalty for a settlement or adjournment more than 90 days out, and then they escalate. And they only really provide partial compensation. It's really some compensation for lost opportunity for busy arbitrators.
I think Jack's done.
Yeah, I had a question for the panel. Happy to follow Mary. She was my student, and she taught me everything I know, so not very much. Canada's a small market, and we see the same players all the time. And in terms of disclosure, I wonder if the panel has some guidance on how far do you go? You'd have, say, Faskins involved in a case in Toronto, maybe in Montreal, and Calgary, totally different issues, totally different people. So, and just how far do you go in terms of disclosure? Over the years, you may have had 10 cases where Blake's counsel were involved, and are you supposed to disclose all of that? And I'm sure that if it's 10 with Blake's, it's probably 12 with McCarthy's and 6 with BLG and whatever it might be. And just how far do you go in your disclosure? Thank you.
Well, Jack, we tried to avoid that because it's an entire topic on its own that would eat up the entire time. But I think Gerry kind of covered off sort of in terms of appointments, minimal protection, which is, I've run the conflicts based on the names you provided me, and I have disclosed what I think is appropriate with respect to those. So at the risk of not answering your question, I don't think we have time to answer your question, because I think it would take us the rest of our time and then beyond. I don't know if there's a disclosure panel coming up, but it was a hot debate at the LCIA on Sunday as well. But if anybody wants to add something quickly before we just give John the floor on the next topic.
It's not on disclosure, it's not on cancellation.
Okay, good.
Hi, Megan Kimberg from Toronto. I just want to give a little bit of a public service announcement for cancellation fees with a horror story. I was counsel in an arbitration where we settled at the last minute. The cancellation fee was on our minds. It was going to be very significant. And it was a settlement term that one party would pay that cancellation fee. And if it had not been looming, the money that would have gone to the cancellation fee would have gone to the other party, right? And then the arbitrator very generously waived the cancellation fee. So number one, it kind of interfered with the settlement that he had no awareness of. And number two, not every arbitrator can afford to waive a 6-digit cancellation fee. So please enforce your cancellation fees for the rest of us.
That is indeed a public service announcement. Council, on the other hand, might not like it quite as much, but so we've got about 12 minutes left to tackle the very small topic of the first procedural conference and the procedural order number 1, which some people look at in different ways. And John's going to take the lead on this. And this is, as I said, it's a topic that I think could go on for days, but let's see how much ground we can cover.
Sure, I'll try to be as brief as I can. The first part of the question is when to schedule the first procedural conference, and the general answer is as soon as possible. Depending on what rules are applicable, some rules will stipulate exactly by what date you have to schedule that first procedural conference. As an example, under the domestic rules of VanIAC, it's 10 days after the appointment of the arbitrator. So those are the types of timelines we're talking about. It's 10 days to 14 days. You'll see, especially in the context of an expedited procedure under the ICBR rules, the first procedural order has to be issued within 14 days of appointment. Again, under the expedited rules of the ICC, it's 15 days within the file being transmitted to the arbitrator that the first procedural conference has to take place. So the timing is very important, particularly in the context of expedited procedures, but when you're dealing with claims that are in excess of the expedited procedures amount, the same kind of principle applies. You want to get the parties together as soon as possible so that you can set the procedure, you can set the schedule, have that in place, and get things moving. To wear just my arbitrator hat for a second, my practice is to give the parties a questionnaire as soon as possible following my appointment about the types of issues that we'll want to speak to at the first procedural conference, to see if we get the parties to think about them and agree upon that ahead of time. So when you're at the conference, you're dealing with the issues in dispute and can kind of spend most of your time with those outstanding issues rather than those where the parties are in agreement. The types of questions that will be included on the questionnaire really relates to the procedure of the arbitration itself. So they're all kind of technical questions of how many written submissions, how many rounds of written submissions, will there be witness statements, how many witnesses, will there be expert reports, how many, how will documentary evidence be introduced, will it accompany the witness statements, will it accompany written submissions, will it be a separate step in the procedure where perhaps written briefs will follow the witness statements. So those types of kind of just the laying the foundations of the procedure itself are kind of the basic questions to be included and to get the parties thinking about that. And then other ones will include, under the VanIAC international There's the possibility for early disposition of any issues that are appropriate for our summary procedure. So, that's an appropriate question to get the parties thinking about. Are there any issues here that can be dealt with, that can be hired off and dealt with at the outset, while the suit itself continues on its track? Another big question, of course, is an oral hearing. If an oral hearing requirement, again, that's in the expedited procedure, it's more the exception, but some cases, regardless of the claim amount, will lend themselves to the potential of having just being decided on documents. Of course, counsel are always kind of hesitant or reluctant to agree or to forego the opportunity to have an oral hearing. But it's something that again, get the parties to think about and agree upon, because at the end of the day, it is the parties' arbitration, so we want to make sure that there's buy-in from them, and that early questionnaire and that early procedural conference kind of gets those things kind of lined up. Perhaps I can turn to the following step up, the following the procedural conference is the first procedural order. And again, from my practice, I like to take the answer from the questionnaire as the result of the conference and provide a draft of the procedural order, the first procedural order to the parties to make sure that it captures everything that was agreed upon and any issues that they might have comments to, so that they know what's coming and what's kind of my approach or what the procedure would be. So that's another kind of best practice that I like to do that is helpful to again get the buy-in from.
So on that one, I'll ask Gerry and Julie. So John said that the first draft of the procedure order goes out after the case management conference, after the parties have had their questionnaire. What about sending out a draft PO1 before the parties have a chance to discuss as a guide for them as to what should be discussed? Is that good practice, bad practice in your experience? Julie, what's that?
I don't usually tend to be that prescriptive. I usually just send an agenda or open-ended and wait and see with the part. I'll encourage them to confer before we meet, and then we'll work our way through it. Often I will get a draft from them, which is fine. If I'm unhappy with it, then we can chat about it. I can try to make my views known, mediate any issues. And some arbitrators think, well, then the council already got the bank, you've already wrecked the process. But I view it as being the party's process, so I'm less prescriptive.
Gerry?
Yeah, that's my view as well. I think it's a very important part of managing the court, coming to understand party expectations. Again, particularly speaking of the Canadian environment, if you're dealing with domestic arbitration, there are widely varying practices and expectations from one place to another within Canada. I think generally in international cases, there's more uniformity in expectation, probably less risk in leading with a procedural order. But even then, I follow the practice that John suggested, which is to send out a checklist of non-leading questions to get input from parties to try and really just to identify where there may be issues. On the domestic side, it's sometimes wise, unless you know the counsel involved and you know their level of experience, it's sometimes wise to take that first procedural conference in 2 bites, to have an initial discussion, to find out in very general terms what the parties' expectations are, and to see if you can arrive at some sort of consensus as to, do you really want to have oral evidence here and direct evidence? Are you really expecting examinations for discovery? Because some people come into the room with completely different visions of how this is going to unfold. So to get an understanding first, and then the task shifts to you. Once you've heard from the parties, if you hear something unexpected or that you think is perhaps unwise, you then have to sort of come into managing those expectations and leading them to what you think is an optimal process for their case. And that can involve, after you've heard from them, sending out an order that is in draft form for their further comment, saying, after having listened to everything you've had to say, this is sort of where I think we should end up. But it's not always the same. I think every procedural order is different. Every procedural order number one is different. Even in international cases, there's always a nuance or two. And so if you could regret, I think if you lead to
So, Gerry's answered a little bit of a question I had, which is, and I'll give a little background for it in a few minutes that we have here, is what do you do with the parties that come to you and they've got, I want copious document production up front, I want 6 weeks of discoveries, I want a 2-month hearing, and what can you do as an arbitrator? And I'm going to just highlight where the rubber meets the road on party autonomy versus arbitral authority. And in the BC Act, we have the standard provision that you'll see subject to this Act and any agreement of the parties, which is their arbitration. An arbitral tribunal may establish procedures and make procedural orders for the conduct of the proceedings. That's in Section 32. Section 21 has the arbitrator's obligations. The arbitral tribunal must treat each party fairly, give each party a reasonable opportunity to present its case and to answer any case presented against it, and strive to achieve a just, speedy, and economical determination of the proceedings on its merits. So if you take the example I just gave and you're sitting there as an arbitrator, you might think, that doesn't really seem like the most economical and expedient way to do this. The BC Act, when it was amended, added something extra, which I've used, and parties, has made parties kind of wake up. And it's Section 22 of the Act, which says parties to arbitral proceedings must do all things necessary for the just, speedy, and economical determination of proceedings in accordance with the agreement of the parties, the orders and directions of the arbitral tribunal. And Part 2 is a party must not willfully do or cause to be done any act to delay or prevent an arbitral award being made. And when faced with that, well, we've agreed that this is what we want and it's our arbitration, I've referred parties to these provisions and said, well, have you thought about a different way that might be a little bit more expedient? And maybe it's because, as John says, when you talk about fees, they're afraid of you early on. But they tend to say, oh yeah, that actually would work, and we probably don't need that once you explain to them what the other options are. So I just throw that out there. We have a couple minutes, one in particular, for questions. 1, 2, 3, 4. You have a mic? Go first.
Yes, thank you. This is Jane Catherine O from DS Lawyers. I'm a civil and commercial litigation lawyer. So my questions are the following. So how, because we mentioned that terms of appointment manage the relationship between the tribunal and the parties. We also mentioned about the procedural order number 1, and also yesterday we talked about the AI's used in arbitration proceedings. I wonder, what are your thoughts about including the parties and arbitrators undertakings with respect to the use of AI in arbitration proceeding in the terms of appointment, or do you think it's better to discuss in the procedural order number 1, or just stipulate them in the procedural order number 1?
I think procedural order number 1, if you're ever gonna have to use it, you don't want it with your commercial terms. So that would be my answer.
I agree with that.
Consensus? Go ahead.
I wanted to just pick up on a couple of things that I was hearing from this panel about what the parties want, party autonomy on procedural matters. And there is a distinction, because it's not really the actual commercial parties who are making these decisions, it is counsel. So one thing that I've been doing increasingly now is inviting the parties in with counsel for an initial meeting. It's not the first procedural meeting, it's the initial meeting where we talk about process. I introduce myself and what the arbitral process is and how it's different from court. and we talk about the commercial parties' process goals. And then they are also invited into procedural meeting number 1. Sometimes they come, often they don't. But even if they don't come, their counsel know what those process goals are. So when we're discussing things and they say, oh, we want to adopt the rules of civil procedure and I want full disclosure and all of the regular kind of things that you hear from litigation dabblers, we test against the process goals that the parties themselves have expressed, and that's a very good disciplinary measure.
Yeah, that's absolutely best practice you can get the parties in the room, because I agree, I've seen the disconnect between counsel and their parties. And you tell with the client there, you say, well, you know, what you're telling me is gonna cost a lot more money, and the client goes, well, what do you mean? How is it gonna be cheaper? Tell me how to make it cheaper. So Janet said I was allowed 2 questions, which we've already had, and we have hit our deadline plus 2 minutes. So it just falls on me to thank our panel members and all of you for participating and listening to us. So thank you.